what is the relevance of that question? And I know that they, obviously, there's a jury instruction to that regard, but how is that relevant?
It ties into this whole suicide by cop idea.
Explain that.
Because nobody in an evaluation wrote about suicide by cop. Nobody asked John about suicide by cop. Nobody said anything about it in deposition about suicide by cop. The first time we heard of suicide by cop was during cross-examination of our witnesses.
Okay.
And that was new to us. So what Dr. Burston then said on direct today was, when asked if this could be suicide by cop, he said, well, two of their witnesses said, hey, if this when they were asked about suicide by cop, they said, well, that's a possibility, and that would mean he wasn't insane.
Well, wouldn't he have been in the courtroom when the state was cross-examining your experts and brought up suicide by cop? Dr. Burston?
Yes.
Okay.
Yes, and that's the whole point, is that we think that this is something that has newly come about as a question, and bias and motive are always relevant, and so it's just a simple question as to whether he's consulted with the state attorneys during the witness testimony. But now that, I don't even know if I want to ask the question, because now he knows how to answer.
Okay, good. Let's
Now that
bring
we've
that
done
to
it all
jury.
in front of them.
Well, let me
Alright.
just say,
No need,
Okay.
let's just bring in the jury.
So she's not asking you questions.
Bring them in.
Deputy Rice, when you got them lined up, bring them in.
Let me ask the lady, can you guys hand her a legal pass? Thank you. And pens?
Pins are all right.
We need them right now? Okay, as soon as she can, bring them in, thank you.
You should have ran back there on the break.
Huh?
Should have ran back there on the break.
It's all right.
Jury's returned in this evening.
Thank you, you may proceed.
Dr. Burston, going back to the suicide by cop for just a moment, that's not something that you talked about in your written report, correct?
correct,
Or in your deposition?
correct.
Nor is it something that Dr. Otto, Dr. Mayer, Dr. Mapless, any of them talked about
In,
in their reports?
no, they didn't.
You're being paid by the state attorney's office, correct?
Yes,
Right. And you've been sitting here through all the days of the expert testimony in this case?
all of the expert testimony, yes.
You're not board certified, correct?
No,
A couple of points that I brought up, want to just clarify a little bit. When I was talking about Michelle using Phoebe's name on the Craigslist
yes,
online stuff, we're talking about like back page type.
Objection asked and answered, Judge.
Not that part, overruled.
yeah, she was into that kind of, the pornography business, for lack of better terms.
You indicated that Noemi told John that she was going to call the police, correct?
Again, asked and answered, Judge.
And
Just give me a moment. What's the question? The whole question?
may we approach?
Yes.
What's that? Noemi, okay, so you said that Noemi told you in these phone, in the text messages on the night of January 7th, that she told John that she was gonna call the police.
Actually, I misspoke. There was a little confusion there with Noemi, and it was in her deposition. She didn't speak with me about it when I spoke with her over the telephone.
Okay. Noemi didn't tell the police officers that she was gonna call the police when they spoke to her right after the event, correct?
I have no information about that. I didn't see that there were any reports of that type, or there weren't.
Would looking at the report help refresh your recollection?
Sure.
May I approach? the top paragraph of Detective Miller's report.
No, there's nothing in this report.
That Noemi was going to call the police.
But she said to the police officer that she threatened to call the police.
I just wanted to clarify something that I think got a little missed, maybe, I'm not sure. John told you that he was looking for the exorcism, correct?
I believe so. I'd have to look at my notes, but
And he's, as far as asking people to put their hands on the Bible and to say things, that's something that he reported to you as well.
on the night of the 7th,
Yes.
he stated that, yes.
Okay. You testified a little bit ago when you gave sort of your ultimate opinion that you talked about John being driven by this pattern of conflict.
Well, that there was, the conflict was building, and creating a certain amount of pressure emotionally, psychologically, and there were other factors that were more immediate, that were very inflamed at the time.
And you talked about this pattern that was building and these other things as being driven by psychosis or being driven by the personality issues.
Well, yes,
Okay.
I said that, yes.
And you said that because it was the personality disorder that in your mind was what was driving John, that he was not insane, correct?
Well, ultimately, yes, but it's a little more detailed and complicated than that, yes.
But if John had been driven by the psychosis instead, then he would be insane, correct?
If I found evidence of that, yes.
Your Honor, may we approach just briefly?
How long will that be, Mrs. Smith?
Not more than 5 minutes.
5 minutes. Thank you.
Jury's out of the hearing, the court, Your Honor.
I just have a few questions about the
Okay, go ahead.
PCLR. The first question I would ask Dr. Burston is the difference between the word psychopath and psychopathy. Could we agree that the difference is a Y, the letter Y on the end of the word?
I guess.
Okay.
You know.
The development of the PCLR2, it was actually developed using a prison population, correct?
Well, there are norms for mentally ill offenders.
The sample of people that it was initially developed on were inmates.
And a sample, or say a subsample, of mentally ill inmates.
Okay. And you were, not you, it was developed to try to identify personality characteristics that these inmates had.
Yes.
And its primary use is for sexual recidivism,
No.
sentencing?
No.
No, okay. What's its primary use?
The primary use would be for, first of all, it was developed to be a measure of psychopathy, and it would be otherwise used, I think, in various types of risk assessment.
Risk assessment, that's the word I
Yeah,
was
but
looking for.
not sexual necessarily.
Okay. So develop for risk assessment and looking for evidence of psychopathy.
Judge, I understand why we're doing this, and I understand the court is probably allowing this, but we have gone through all of this at the hearing prior to the trial. I'm not sure why we're doing it again. I would object to that, but I understand it. It's the
Well, I
proper, so
thought
the
the
court
same
may
thing.
allow it. I
But I
understand
think
that.
it should be part of the contemporaneous record. Go ahead.
I understand, but I want to put my objection.
Yes, I
on
know,
the
I already thought that. Go ahead.
You said it was for developing evidence of psychopathy.
Features of psychopathy, yes.
Features of psychopathy.
That's the purpose of the test development.
And when you were on direct, when you were going through the various 1 through 17, the various measures on the assessment, you were telling us basically what the manual was saying each of those things meant, correct?
Yes.
And you were not able to give us really examples of how that related to John, correct?
Other than the score, I mean, that's the ultimate example.
Okay. Well, and you were not able to give us the ultimate score for the assessment.
Oh, come on, Judge.
Yeah, I was
What?
just thinking of that. Okay, let's make it clear. You objected when he got in to some of the particulars. I stained it. You wanted the 3 things off the bottom. Probably wanted a lot more than that. I took them off. And by virtue of that, you couldn't get into the score because it was meaningless. So the things you're proffering supposedly you didn't do are the things you asked for.
That was my-
No.
that was my whole
that's
point. That's
No, it's misleading. If
Okay,
he's convicted, some district court's gonna be reading this, and it's misleading. 'Cause
That's all I
It's
had.
not how it happened. It
I
happened because you didn't want it, and I agreed with you.
understand. I
Okay.
just wanted to do the proffer to perfect our record on the issue of the
But
entire
that's
thing
not
coming in.
the issue. Do you have anything else?
No, Judge.
Okay, let's bring in the jury.
Deputy Rice, line them up, bring them.
We'll just say for the record that because she asked the question, you didn't provide examples. We obviously had the examples that could have been provided. I just
Well,
want
I
to
think
make
that,
that,
no,
I
we're
think
done.
that's
I
a
think
given.
that's what I said.
Right.
Okay. Yes, we're ready. Thank you. It is what I said, right? Yep,
Okay.
For the record.
for the record. You finished, okay, redirect?
No questions?
Okay, can Dr. Burston be excused?
I'll
Stand
stand
by.
by, Judge.
Stand by, okay. Do you have any questions? Okay. Thank you. First question is the schizo-psychotic diagnosis. I knew what it was before. Schizo-psychotic diagnosis. What is that word? PAVES? Based?
I forgot the question.
On the first question.
Diagnosis takes 6 months. Why?
Okay.
Well, I think that it has to do with very simply determining that it's really there. Because symptoms can manifest for a number of reasons and either change or go away. So when someone shows psychotic symptoms, they could be for any number of reasons. I mean, somebody could somehow ingest some prescription medication that they just have a terrible reaction to. Of course, drugs, which has been brought up. So when the symptoms persist over a 6-month period of time, and ideally longer, then we're sure that what's there is there.
Did that answer your question?
Yes.
Okay. All right, this is from 1179. What processes do psychologists use to differentiate whether Mr. Jonchuck's statements are true or a lie? Question mark.
Well, there's a few different ways. One is comparing certain statements to facts that have been well substantiated elsewhere. I think that would probably be the most reasonable way to make that decision. Sometimes people who have certain conditions, mental health conditions, of course, can fake symptoms. I'm not saying that's relevant here, but just to answer the question more broadly, there are legitimate forms of mental illness, and then people's presentations that just almost are laughable to a psychologist if someone's trying to fake, say things or present symptoms that are just preposterous. The other issue, the other way to make that decision would be just, well, I think those are the two main ways, I guess. I'll leave it at that.
Okay, and the last part of it is, or do you automatically assume it's true? I think you've already answered that.
No, you can never automatically assume anything is true or false. Everybody, you have to talk with the person and get an idea of where that person's coming from, what their response style is. If they start immediately telling you information that's very divergent from information you've reviewed. And then, of course, sometimes certain things mean less than others given the circumstances of a case. So, but usually there has to be some sort of corroboration for important questions. I guess that's the best way to put it.
Does that answer those two questions?
Yes.
1179, does that answer your question? Okay. Anybody have follow-up questions based on those two before we get to the others? No?
No.
Okay. We're going to take about 5 minutes and discuss whether the other two questions can be answered, which requires a trip back. Thank you.
Jury's out of the hearing, court now.
Okay, Dr. Burston, what would be your answer to this? What was the source of the defendant's preoccupation of jumping off bridges?
I don't have any idea.
Okay. And Can you expand more on Mr. Jonchuck's obsession with bridges?
No, other than that, it was in the records. He was obsessed with that. I can't speak to the origins of the obsession.
Okay, do you have any questions?
Well, I think based upon those answers, that the question should not be asked.
Okay. Do you have any follow-up questions to determine whether?
No, Judge.
Okay.
So that was it?
Yeah, I'm trying to decide. I'm not gonna ask it. All right, let's have it back in, please. And I'll dismiss it for the day, 9 o'clock?
Yes, Your Honor.
Tomorrow.
Judge, I think next witness up is Dr. Lazaro tomorrow. The court had indicated we were going to do some proffering. Do we want to tell the jury
Josh,
later, or?
Bryce, bring them in.
Well, I have no clue, because I don't know, what, 1,000 pages you got this morning?
700.
700, I don't know what, I don't know, you all would know better than I do. I don't know what's in there, I
Well,
don't know.
My concern, there were two things yesterday that the court indicated you were going to do some proffering of before Dr. Burston testified, specifically regarding the elements on the PCLR of
Which we did.
I objected and asked to approach, and the court did not allow me on the
Okay, but we
callous
did the
and
last three we
impulsivity.
took out.
Right, we took out those two, but the court had indicated that you saw problems with the callousness and the impulsivity, and that we would discuss further, and then I objected, asked to approach today, and we weren't able to, so I'm just trying to get an idea of what, if we are doing a proffer, if we're not doing a proffer.
Well, I could suggest.
So let's bring them in and then we'll discuss it, okay?
I was just
Well, it depends what time. Should I tell them 11 to be safe?
I'm sorry, Your Honor.
11, because something's gonna happen, I'm sure.
I wouldn't be surprised if they give us more documents tomorrow.
Well, whatever, something will happen. So 11, would that be reasonable?
Yes.
Okay. All right, so I'll do that. Let's have him back in, please.
All right.
Jury is in the jury box in seating, Your Honor.
Thank you. Ladies and gentlemen, the last two questions cannot be answered, and with that, I'll excuse you for the evening. And we have some work we have to do tomorrow morning, which could take a couple of hours, so I'm gonna ask you to come back at 11 o'clock.
Okay.
Thank you very much.
Thank you.
Thank you. Sorry.
Jury's out of the hearing in the court, Your Honor.
Thank you for your testimony, Dr. Burston.
Thank you.
I could address something with Dr. Lazaro.
What?
I could address something with Dr. Lazaro.
Okay.
real quick. So, I spoke with Dr. Lazaro extensively last night. We'll talk to her again today about the court's rulings, about what can come in.
Well, revisit it, make sure that that
Yes.
is my rule. Tell me what you told.
I have my notes back at the office, but I
Well-
said with the PCLR, those last three are coming out.
Right.
I said that you don't want her referring to any of those items in the PCLR as name calling to him, but those are traits of psychopathy, and that he has those traits.
Okay.
So I kind of explained how you want that to go. If the defense wants, we could proffer the PCLR part of that when we get to it. She does want to give specific examples, kind of like Dr. Burston did. So we came up with some examples for each one last night. I could share those with the court tomorrow morning. I think most of those are already things that are already in evidence. So I think that will go smoother. I know the defense is still objecting, but I think most of those examples are relationships and specific examples like waxing the stairs.
And we
things
did
that
have a
are-
bench conference on waxing the stairs.
The bench, right, I'm waxing the stairs, I agree.
Okay, go ahead.
And I have the list back in my office because it's a whole box for her, but.
Okay,
So I discussed that with her. I told her it's psychopathy. We're not saying psychopathic or
that the
psychopath.
defendant is a psychopath.
Yeah, we're not saying that it's psychopathy. She's obviously good on all those things, so I don't think.
Okay, and anything about victim impact, like,
Right, I told her we're not
all
talking.
those things.
I told her we're not discussing sympathy. Sympathy is not something the jury can consider. Sympathy for the victim. So.
well, anything about her estimation of the heinousness of the offense.
Right.
Or any, I mean, it has nothing.
I discussed that with her
Okay.
specifically. Yeah.
All right, and there's something else to it, I'm trying to think of what it is. Oh. She gave some characterizations in the brief excerpt I had from the report that the defense gave me, describing Mr. Jonchuck in various ways, which I would not allow.
The cold-blooded psychopath? Is that what you're referring to?
Evil.
Right.
Yes, the cold-blooded psychopath and evil
Okay.
are the things that I remember specifically.
I discussed the cold-blooded psychopath. She knows she's not saying that. I don't think I went over the word evil, but I'll mention that to her tonight. Based on my conversations with her, I can't imagine that she could say that, based on what I've told her, based on your rulings.
Okay,
But I'll address that specific word with her.
that's what I know about, I don't know about anything else.
As to the PCLR, we are challenging her testimony of
I
that
understand that.
based on her qualifications.
I
So
get
we
that.
are asking the court
Okay,
to.
so we're gonna have to do that. Based on her qualifications to get it, right?
Correct.
So can I just ask what the legal basis is that they're
Well, I
challenging?
think I know what it is.
Because it's not,
Well,
we're not under Daubert anymore, so.
No,
it's-
no, I think what they're gonna challenge is the fact that if it's true that she gave it and she was untrained, and then she got the training and she gave it again, is that what it is?
She didn't give it again.
Oh, I heard she gave it again.
She did it, then got the training after her, since her testimony and everything.
Well, she was trained. She was trained by her mentor, who's a psychiatrist, and she discussed that in her deposition. So
Well,
it's not like she just picked it up and did it for the first time with the defendant. She's done it before. She's testified to it before in other cases, and she was trained by.
insanity cases?
No, but I just mean she's administered the test before and testified to those results before.
If I recall Dr. Burston's testimony at that hearing we had, is that the training was difficult, specific, had certain requirements, and that giving the test as a subjective test without the appropriate training would be problematic, if I remember his testimony correctly.
Right. And she is going to testify that she was trained. She was trained by her mentor, who's a psychiatrist, and she gave the test and came up with basically the same results. So I don't see how they can exclude that.
And as far as any training.
Hold on, I'm just deciding whether to have the hearing or not have the hearing.
Well, that's what I was gonna say. I think that's a point of contention, whether she was actually trained originally. That's what we'd be asking the court to obviously make that determination.
Well, I guess everybody concedes that she wasn't trained in the way that Dr. Burston suggested that those individuals using that tool should be trained.
Well, actually, Dr. Person on the stand today said, Judge, there's a couple ways to do it. One is to go through Hare and his people, and another way is, there's other ways to be trained for it. He didn't say that it had to be either way. He said you can be trained for it outside of Dr. Hare and his associates, and there's nothing wrong with that. That's what he said today.
Okay. Ashley's the mandatory training today, but I would still be asking the court as to whether she was even trained in her fellowship is a question. She indicated in her report that she loosely applied the hair psychopathy criteria. She believes she received some training from her mentor during her fellowship. She was unaware of any of the research regarding the reliability. She was unaware what confirmation or confirmatory bias was, let alone what Dr. Hare has indicated the necessary ways to protect against it. So I think there's certainly some issues for the
Okay.
court to
And
consider.
I would also add, I believe that she did actually her training not too long ago, or that's after the fact. That's subject for cross-examination for them to attack her. You know, if you did the training after you gave the test, that's the right to cross. But the fact that she did that training and she still is offering the same opinion, I think means something.
Well, I'll hear it, and what comes of it comes of it.
What time do you want us
9.
here? Okay.
Could we do that right off the bat, that way we get that out of the way?
Mhm.
Because obviously, if
Yeah.
that's out, changes things for us. We'd have to kind of take a few minutes to figure some things out. I mean, you would agree that's a part of our testimony.
Okay, so anything else? No? And the 700 pages of her prior testimony, I'll just deal with that when she's on the stand, or I shouldn't even ask, or
About what?
the 700 pages of her prior testimony at other proceedings.
Well, I'd like to know, and we can talk about it tomorrow, but I'd like to know where they're going with that. They can impeach her based on bias. I think that we all agree on that. Or the fact that they believe that there's bias. I'm not saying she's biased, but that's bias is always something they can impeach on. They can't impeach on prior bad acts, or things that she may have done.
Judge, the defendant is leaving his,
Do you want to waive, Mr. Jonchuck, the rest?
Of today, yes, Judge.
So you're going back because you want to get out of here, right?
Yeah,
Okay, thank you.
all right, thank you.
I think it would be
Our problem is,
a
Judge-
huge waste of your time.
Okay.
Judge, our problem is, we can't tell you whether you should read it or not because we just got it dumped on us this morning by the defense. 700 pages, once again, late evidence to us. And that's the problem, we can't tell you whether